I was speaking to nobody. Anyhow, just to say welcome to our attendees. I see lots of colleagues, Professor Stazzi, Professor Las Casas, Professor Cascione, Professor Rojas, Professor Vagni, Professor Colangelo, Professor Salvadori, Professor Vardi, Justice Sabato from the Court of Human Rights in Strasbourg, Professor Vidaschi from Milan. And I think we can, as all the panelists are here, and it's 6 minutes past 6, I just, before then I will ask to remove the slide that is posted there, which is just a list of possible topics. Just first of all, I would like to thank everybody for all the panelists for being joining this final webinar, but special thanks go to Antonia Baraggia and Giorgio Giannone Codiglione. Giorgio Giannone is hiding behind the logo of the Italian Association of Comparative Law. If you just remove it, you will see him. But thanking them for the great work they did in organizing the previous 9 webinars and this last one. A great thanks, obviously, to the Younger Comparativist Committee of the American Society of Comparative Law, and to the President of Younger Comparative Committee, Antonia Baraggia, and to the President of the American Society of Comparative Law for having organized this initiative with us. Just a title, Comparative Law, Après Le Déluge. Well, I suggested this topic well, over a month ago, 2 months ago. Hopefully that on the 25th of June, we would be out of this pandemic flood. In Europe, things seem to be more sort of moving out. In the Americas, things are still complex, but I think we have already lots of lessons we can learn from what has happened over the last 4 months. By the way, Après le Déluge is not a quote from the French monarch who said Après nous le déluge, but it's a poem by Arthur Rimbaud, and which is quite used in literary sort of as an expression of what you do after the flood. So having said this, the topics you've seen, some of the topics that that may be tackled in this webinar, they are obviously, the idea is that this pandemic maybe has changed some aspects, not only of the law, but also of comparative law methods and objects. I will not enter in this field because probably there'll be divided opinions on this, but I just, from legal realistic point of view, I just say that things have changed. When you find thousands of pieces of legislation which have been enacted in all jurisdictions, thousands of them, and you find thousands and thousands of comments and articles from a legal perspective on this topic, I think something has changed objectively. The sheer fact changes the scenario of the law, and therefore maybe also of comparative legal research. But I think I will stop here and give the floor, first of all, to Professor Richard Albert from the University of Texas in Austin. Welcome. The web is yours. The Zoom meeting room is yours, Richard, and welcome in our conference.
Well, thank you very much, Vincenzo, the chair. Thanks so much for convening this group, for agreeing to chair it. I want to begin by just saying thank you to Antonia Baraggia and Giorgio Giannone Codiglione for organizing really this remarkable virtual gathering. 4 weeks of webinars, 10 different webinars, new topics and methods in comparative law research, the subject of the gathering with participants from Canada, the US, Italy, Turkey, Slovenia, Germany. I could go on. It's really a remarkable effort that Antonia and Giorgio have managed to put together. So congratulations to the two of you, and also to the AIDC leadership, and also the YCC leadership, including, of course, Antonia, the chair, and Vera Corzan, Valentina Scotti, Sarah Ross, and Claudia Haupt, the YCC board. It's, again, it's really, I sit in awe and amazement at what you've created with this 4 weeks of virtual gatherings. We're now meeting in the year 2020, and it's an important year in the study of comparative law because it marks the 120th anniversary of the formal study of comparative law in a particular way. 120 years ago, as most of you, all of you perhaps know, in 1900, scholars gathered in Paris for the very first International Congress of Comparative Law. Of course, it's true that scholars studied comparative law before the year 1900. I learned in university, as many of you probably did, that Aristotle, for example, was an early comparatist. He studied many of the world's constitutions to try to determine what makes a good constitution, what could be a model constitution. And so, of course, comparative law is not 120 years old, but our organized gatherings are relatively new. And so it's important, I think, moment to mark this 120th anniversary when we gather together across the world to discuss these subjects, the scientific study of comparative law. We were supposed to do this together this year in person in Perugia for this event. And so I regret very much that we can't do that, but I'm grateful again to Antonia, Giorgio, all of you for allowing us to gather virtually with great ease and also in the comfort of our own homes. I want to stress comfort because you see me on your screens and I'm wearing a jacket and tie, but you cannot be certain that I'm not wearing shorts and sandals in the lower half of my body. That is at least part of the beauty of Zoom. And so again, we gather with great ease virtually and also in great comfort. There's a lot to discuss on the theme of this closing plenary panel on comparative law, Après Le Déluge. Hopefully there'll be time for discussion, but for the time that I have, and thank you to the chair for giving me this time, I'd like to speak to the concerns of early career scholars, early career students who are here with us in this virtual room. This is, after all, an event co-sponsored by the YCC, the Younger Comparatist Committee, and it's important to me that we recognize that early career scholars are confronting the present public health emergency with concerns that are not only quite serious, but that may very well be unique to them in some ways. And so the focus of my short remarks then will be directed to early career scholars. Of course, I'm sure the entire panel assembled has thoughts to add. This is just a beginning of a few thoughts that I want to raise that will focus on the following theme: 3 new realities for early career scholars, 3 enduring challenges, and 3 opportunities to thrive in the new world après le déluge. So 3 new realities. Some of these may be obvious. In fact, all I think are obvious. The first is that academic travel will decrease. It already has for several reasons. Some of these reasons are obvious and others are not. Of course, we cannot underestimate health concerns. That's first and foremost. But let's not also forget the cost to universities now facing increased budgetary pressures. Should we subsidize travel to conferences when those gatherings can be done like we're doing now, virtually on Zoom or WebEx or some other forum for us to gather virtually? I think the Zoom revolution will be a reason why academic travel will continue to decrease after we return to whatever normal is, whatever the new normal might be. The cost-benefit analysis just does not weigh in favor of returning to what we used to do, which is to travel around the world and gather in person for short periods of time when those monies can be directed elsewhere. Now, many fear that the decrease of academic travel, many fear that the new world will make it harder to do many of the things that we are used to doing, that early career scholars, you are used to doing, that you need to do. For example, it may be harder now that you can't gather in person to get feedback on new work from expert audiences. It may be harder to network with scholars in your field. It may be harder to find ways to disseminate your ideas and your scholarship. But I think the new world could be better in some ways on each of these three fronts. And I'll say more about that when I speak to opportunities that lay ahead for early career scholars to thrive in this new world. That's the first new reality, is the decrease in academic travel. The second new reality is that I think the era of big mega conferences is now on pause, obviously, but for how long, who knows? Who knows if we'll ever return to the days of the big mega conferences. For example, the Law and Society Association, an American-based association that has international footprint, of course, moved its conference online this year, just a few weeks ago. The American Society of Comparative Law has moved its conference online for this coming October. This conference moved from in-person to online. And of course, those of you who are aware of the International Society of Public Law didn't hold a conference. A big mega conference was not held. When will people feel safe to travel again? When will universities allow sponsored travel again? Here, for example, at the University of Texas at Austin, faculty and students are not permitted to travel abroad for sponsored academic purposes. So I couldn't go to Perugia. Even if you invited me to come in person, I wouldn't be allowed to go. But again, the online tools have intervened to help. LSA, ASCL, this conference held online. Another point I want to just flag with regard to this second new reality is that in the old world, there were already massive inequalities in who could travel to these mega conferences, who could go to LSA, to the ASCL conference, to the ICON-S conference. Parents were often unable to go. Those with physical challenges or disabilities could not. And of course, those without funding could not go. It may be that the new world, with its move to online gatherings like this one, will democratize academia in a way unlike ever before, and in particular, the comparative law community, which relies on people from various communities, various traditions, various parts in the world to exchange ideas. We're doing it very easily now in this forum. The third and final new reality, Après Le Déluge, is that faculty hiring may slow down and in fact may stop for some time as universities determine what form education will take in the years ahead. You see now I'm speaking to early career students and scholars. This is something that's top of mind to them. They've invested all of these funds, all of these monies, their time and resources into getting a degree in law in advance of joining the professoriate. We're in a period of transition now. We are in a crisis, planning for the end of a crisis that may have no predictable end to it as far as we know. So what will university and student life be like in the years ahead? What will faculty life be like in the years ahead? I think for scholars of comparative law, the future is even more precarious than for those in other fields, because already in North America, here I don't want to speak to the other parts of the world where I'm not involved in hiring, but in North America, those who focus on comparative law, broadly understood, including comparative public law, comparative administrative law, international law is sometimes in this category, but sometimes not. It's considered a luxury hire. So comparative law hires in North America are luxury hires. Not every school can afford to hire someone who teaches comparative law, who writes about comparative constitutional law. So in North America, it's important to pair an interest in comparative law with a domestic subject, torts, for example, contracts, for example, procedure, for example. I'm not sure how strongly that resonates with jurisdictions outside of North America, but here it's a concern. So North Americans on the call here, early career scholars from North America planning to enter the North American teaching market, it's very important to pair an interest, a scholarly interest, not only in comparative law, but with a domestic subject. So these are three new realities: travel, mega conferences, hiring. Now, there are three enduring challenges that this current public health emergency poses, but these are challenges that may get worse. Après le déluge. First is wellness and mental health. It's always been a challenge for graduate students and early career scholars to care for themselves in the way that they should. The pressures are enormous. And I'm not just speaking about tenure. Tenure is very hard to get in North America. But I'm speaking of the isolation of the life of a scholar. It's an all-consuming life. It's a devastating workload. But of course, I say that, but I love what I do. So for me, if you tell me I have 10 hours of uninterrupted time to write, thank you. This is like winning the jackpot. But it's time that I spend alone. It's all-consuming. And oftentimes in academia, there is very little separation between home life and work life. And so the move to the online world, I think, will exacerbate this enduring challenge. Teaching is now online. It may well remain that way for some time. Conferencing will be done online for some time. Your entire day may be done online, from teaching to meetings to reading and writing. It may be that this will generate a kind of online fatigue. And so this enduring challenge of wellness and mental health is not going to change after we enter the new world. It may get worse. And so we need to think about how to support our early career students and scholars to make sure they have the resources to handle the new reality. A second enduring challenge, après le déluge, is the establishment of mentorships. It's always been hard to establish mentorship relations, especially the ones that don't feel forced or artificial. I remember when I joined a faculty for the first time, I was told, meet so-and-so, this is your assigned mentor. It's very artificial, isn't it? Not clear that there are overlaps in interests, not clear that we get along in terms of personality. Establishing mentorships, especially when you cannot connect with someone face-to-face in a conference setting or in an academic setting that's different from your own, that's going to continue to be hard. Maybe even harder without the personal face-to-face interactions that usually ignite relationships in academia. One third and final enduring challenge that may get worse after we enter the new world is the costs of education in academic life. And here I'm not just speaking about financial costs. Financial costs, of course, include tuition and books and supplies and computers and travel. But there are life costs, rent and food and family care, personal care. It may be that we find our early career scholars doing stuff that brings them out, pulls them away from academia, maybe part-time jobs outside of academia, in addition to their teaching obligations as teaching assistants or fellows. It may be now that they have, on top of their academic responsibilities, family care in this public health emergency that will really put some pressure on how they can advance and improve their prospects for the hiring market. Or if you're already a faculty member, how you can work toward publishing and keeping up to date in your reading. Where will the money come from to help fill holes in a student's budget or an early career scholar's budget? It's usually the case that universities have emergency funding available, not just for faculty, but also for students. But there will be increased demand for these funds. How will these choices be made about who gets emergency funding relief and for what purposes? Challenge that universities will have to face, and that I think we should all be aware that our colleagues in the early career track are going to have to confront. So I've spoken about three new realities: travel, mega conferences, and faculty hiring. Three enduring challenges that existed before this present public health emergency that will exist after and may get worse after. And now let me maybe turn to my final points, which are three opportunities for early career scholars to thrive in the new world. So we've had three new realities, three enduring challenges, and now maybe three opportunities for early career scholars. First, collaborations and peer learning have never been easier than they are now. Co-authoring, for example, is a great way to develop your research, to continue to network, to deepen your interest in a certain field. Co-authoring in a way that complements your existing strengths. So you marry one language expertise with another. Marry language expertise with someone who does data statistical analysis, for example. Marry doctrine with technology, theory with history, comparison with anthropology. Co-authoring and collaborations have always been around, but it's never been easier than now with something like Zoom, where you can exchange ideas in real time, rigorously, online as you develop your scholarship. Second, it may be that there's a great opportunity for first movers. There's a first mover advantage always in innovation, but there may be a peculiarly big advantage for those first movers who can innovate in academic life. We have all these new platforms for engagement. Not just YouTube, which has been around for some time, not just Facebook or Twitter, but like WhatsApp or Instagram or TikTok. I don't know what TikTok is. People tell me it's a new thing, but these are new platforms that the next generation of scholars could exploit to their benefit. There's a great first mover advantage when you do something new and exciting and you're the first to use a new platform for academic intellectual engagement in a new way. So there will be innovations in scholarly production in academic life that will migrate into these new worlds. I don't know what forms these innovations will take, but I'm certain that they will happen, likely in ways that we do not yet know and cannot yet imagine, but that's an opportunity right now for the next generation of scholars, early career scholars and students right now to think about how to exploit these new ways, not only to deepen their knowledge about their field, but more importantly, to disseminate what they have found, disseminate their research, to create academic communities online in ways that supplement their existing connections and networks. Finally, the third opportunity I want to just put on the table is academic entrepreneurship. If you as an early career student or scholar want to discuss something, want to think about something, but no one is convening a forum for the discussion, you should organize it yourself. There's a famous line from a movie, in fact, a book. If you build it, they will come. If something interests you, it's likely that it interests others, and they will come join you in that effort if you do the necessary planning and organization to put it together. The returns can be very high. Just last week, I received an email invitation from a group of undergraduate students in Brazil saying, we'd like to organize a series of conferences online on Zoom with people in whose work we're interested. Would you like to give a talk? Are you available? Of course, I said, yes, this is fun. Me, a chance to get to know some students who are interested in the study of constitutional change and amendment, for example. But you see, this is an example of academic entrepreneurship. Build something and people will come. There's so much to say about challenges in public law. I've tried to focus in my remarks on the concerns that are facing early career students and scholars. I've tried to outline 3 new realities, 3 enduring challenges that may in fact get worse, and finally 3 opportunities for early career scholars. I'm sure there's much more to be said on each of these categories, and perhaps our panel will have a chance to say something in a moment. But I just want to close, Vincenzo, if I could, with just 3 additional items to consider about which we can certainly have a discussion later on or another day. And that is more generally about, I think, what most of the panelists will be discussing in the time they've been allotted. I've tried to focus on early career scholars particularly, but now the substantive parts of the present public health emergency. There's great value, I think, Vincenzo, of comparative law in understanding how the present public health emergency will put pressure on 3 different parts of our public law apparatus. 1 is the separation of horizontal powers. 2 is the separation of vertical powers or federalism. And then 3rd is rights. So first, on the first point, the separation of horizontal powers. Comparative law can, and I think will, help us understand whether the executive branch is doing what many people think it is doing, which is arrogating to itself powers at the expense of the legislative branch, for example. Comparative law will also help us to understand how effectively and whether courts are serving as a necessary check on political actors who claim the need to act expeditiously in the face of the present emergency. There's a new paper by Tom Ginsburg and Mila Versteeg that actually undermines the conventional wisdom, which is to say that the executive branch is sucking up all the authority and that there's no check on its actions in this time of emergency. So comparative law, and that is a comparative law paper, will help us understand what is happening empirically around the world. Second point I think is worth mentioning, because comparative law will add great value to this discussion, which is federalism, or the separation of powers, vertical powers. So on the second point of federalism, comparative law will help us understand whether there are mechanisms or devices that federal states can deploy to help accelerate an end, or if not an end, a steady management of this health crisis. Federalism can work in different ways. It can generate centrifugal forces or centripetal forces. So what are federal states doing to manage the crisis, and which kind of forces are being generated by the choices that the center makes in relation to the periphery, the states or the lender or the provinces? I know that Antonio Baraja is working on the theory of conditionality. Here in the United States, there's a spending power that Congress has. It can impose restrictions on the receipt of funds given to states. Is that a way that the central government can help to manage the crisis by imposing, with strings, imposing conditions on money received for how it manages a crisis? Here in the US, there is kind of a pizza parliament management of the present public health emergency. You have one state doing this, another state doing that. There's reluctance on the part of the federal government to find a uniform solution for this. Conditionality is a way, perhaps, ahead. Are federal states using this? How are they using it? And then moreover, will these mechanisms, let's say the imposition of strings on the receipt of funding, will these mechanisms and devices expire after the crisis? Or will they remain in use, perhaps to the detriment of the sub-state or subnational diversity that federal states are built to accommodate? And finally, Vincenzo, just 30 seconds, talked about horizontal separation of rights, vertical separation of rights, of powers, and now rights. The budgetary pressures that all countries around the world are facing are huge. They're enormous. What will happen to positive rights delivery? Will positive rights delivery, which require the expenditure of funds, will they take a back seat? The right to health care, the right to food, the right to shelter, the right to clean environment, the right to a job, all of these require some expenditure of funding. I suspect that healthcare will, of course, balloon, as it always does in moments like these. But what about the other positive rights that require expenditures? Will states continue to keep funding them? Somewhere will have to be cut. What will go first? And what happens après le déluge? Does the funding go back up to where it was? Does it remain down? What is the discourse around this? So, as you see, so much to talk about, but so little time. I'm pleased, however, Vincenzo and fellow panelists, that I've been able to spend the bulk of my time focusing on early career students and scholars, both because the YCC is a co-sponsor of this program, and because it's important, I think, Vincenzo and others, that early career students and scholars know that we are thinking about the challenges that they're confronting. And it's important that they know that we, I know Vincenzo is, are here to help them navigate what are certainly turbulent times for them and their loved ones. Once again, thank you, Vincenzo, Antonia. Thank you so much for this invitation. It's been a pleasure to be part of this group. And Giorgio, thanks to you.
Thanks a lot to Professor Albert. I think it was very useful because among our attendees, there's a whole lot of young scholars who surely have learned a lot from this, your presentation. And I've just posted for everybody, I've given the link to the article, the two articles by Tom Ginsberg and Mia Versteg, and so on our website, Comparative COVID Law, which has over nearly 1,400 articles and comments on the pandemic. So it's a very rich website, and we've tried to use it as a repository. Just one technical information. Those who want to, I suggest that mostly attendees can use the sorry, the question and answer small slot that they find at the bottom of the screen. So if they want to send comments and so some people can answer, we can see what if the panelists can answer directly to the questions that are put to them. And now, as your final observations on sort of separation, vertical, horizontal, and rights issues somehow have opened the debate, and I think this is what Professor Giuseppe Franco Ferrari from Bocconi University in Milan and Vice President of the International Academy for Comparative Law. So I think this will be the topic of his speech. So the web is yours, Giuseppe.
Thank you, Vincenzo. Thank you so much for the invitation to be here today at the final session of this multiple webinar, and also for the stimulating suggestions that you submitted to us both for today and possibly for the next Congress of the Association. Many of the questions that you posed are intertwined. I would like to begin with some general considerations about the way of carrying out research in times of pandemic before switching to the topic that we decided I should talk about, which is public law in times of pandemic. I might be wrong in formulating forecasts in this moment, because probably we should wait for the virus to fade away, then to come to a stop, concentrate on the new habits that we have been relying on in the last 3 to 4 months, and think it over seriously. As of today, I dare say that the pandemic might have had some very few positive effects. One of them might be forcing us to do research relying on databases only. Of course, it depends on my generation, but nowadays, unless one has to check some historic documents jealously lodged in a library, probably a normal scholar can accede to enormous amounts of materials simply keeping on sitting at his or her table. For those of my generation who were accustomed to work exclusively on the paper, at least of the beginning of their career, it has been increasingly useful to get accustomed to electronic databases. And this kind of forced vacation has compelled us, or at least me, to rely only on electronic sources. In the short run, I think it has been useful to become more and more familiar with the new method. We have been compelled to browse around with more intelligence, more curiosity, like hunters in search of the fox. I recall when I was a young Fulbright scholar living in Charlottesville and moving to the DC almost every weekend, I used to attend the Library of Congress. And at the time, after checking paper cards, because there was no electronic catalog, it was possible to get only 2 books a day. And the librarian had them come up from a kind of well. You were allowed only to keep the 2 books for the day, for that day only. Now, one can obtain all the materials he needs in a few seconds, download them or read them through, and then get out of the site. Such an approach has become extreme in these days of staying at home. I believe that this experience has been formative, at least for me, and at least in the short run. Although I understand that as soon as the virus fades away or abates, at least we probably will feel the need of going back to touch and even to smell paper. Probably the right solution is something halfway between electronics and our old habits. Nor do I believe, because you suggest this idea that we are under risk of becoming armchair scholars. I think that as soon as the virus abates, we will need the usual kinds of socialization that I already miss, actually. As far as the territorial dimension of comparative law is concerned, I think there's nothing new, because we already had reached the conclusion that the so-called Western legal culture can no longer be the only perspective of comparison. It was at least in 1989 or immediately later on that we, after the so-called presumed end of history, we realized that we needed to widen the range of our research. The same conclusion that most authoritative historians from von Humboldt to Meinecke reached centuries ago. Coming to my topic, the future of public law after the pandemic, I think that the first question is, has the pandemic been a real turning point in history, able to compel us to a real change of parameters like an Kuhnian revolution? I doubt it. I don't think so. Like never before, in the new millennium, constitutional law has been transformed into a global doctrine, a part entière, as Lucien Febvre used to write, that makes much more difficult a general framing of our discipline in the new dimension in rigorously scientific terms, in a perspective that overlooks local, national, and continental narratives, but including them all, necessarily with a comparative approach. After dominating the geographic comparative perspective, though at the cost of an enormous mobilization of intellectual energies, we still have the problem of the historical perspective, of which we cannot lose sight, notwithstanding its different possible interpretations. From this viewpoint, the question is, which is the place of pandemic in the structure-event relationship? Lucien Febvre mentioned this problem of the possible cohabitation between a history carried out through specific events and a structural history. And there was a famous quarrel with another great historian in 1974, the Italian Rosario Romeo. In other words, can the sanitary emergency be a sufficient cause for the search for new general paradigms? Is it able to trigger the transition to a new structural form? It is possible that we, in this precise moment of our lives, overestimate the event and run the risk of writing an histoire événementielle, using still the words of Lucien Febvre, imposing on constitutional law and on constitutional law scholars a useless or premature effort. I think that a satisfactory answer is not yet possible. A thoughtful reflection is recommended. The concept of scientific revolution is likely to be reserved to occasions of real cultural upset. There have been several occasions in the last 2 centuries where, when some scholars have spoken of a crisis in the theory of public law, sometimes without any connections with precise historic events. The most famous text, at least in Europe, would be the introductory lecture by Santi Romano at Pisa in 1909, which is often commented by scholars of different nationalities. In the 50s of the last century, another great Italian public law scholar, Vittorio Emanuele Orlando, mentioned a law worldwide crisis. It was 1953. Santi Romano was obviously referring to the contemporary conditions of state law after some dividing lines in the history of the 20th century, such as the emerging of universal suffrage, the emerging of mass political parties, at least in Europe, and the transition from the old traditional liberalism to societal and political pluralism. Orlando, who had survived as an old liberal the 20 years of dictatorship, was referring to the total renovation of the world context and the global transformation of public international law, something I believe more serious than the pandemic that we are hopeful to be able to overcome. Other public law of the past, public law scholars of the past, in their legal system have perceived crucial passages in the evolution of their political system as real cleavages between phases in the development of domestic public law. In the United States, for instance, at the end of the 30s, administrative law scholars perfectly realized that with the New Deal, a new era had begun, and the masterpiece that marked the beginning of the new period was the book by Jim Landis, dated 1938, The Administrative Process, which foreboded the approval of the Administrative Procedure Act of 1946. In the same way, at the beginning of the 80s, the politics of deregulation marked the birth of a new era, and many scholars perceived it immediately. However, American scholars tended to be very generous in the use of terms such as era. I recall Grant Gilmore, The Ages of American Law, transformation, Morton Horwitz, reconstruction, Bruce Ackerman. In Europe, at the beginning of the 90s, a cluster of events, which is very difficult to summarize shortly now, such as the end of communism in Eastern Europe, the adhesion of many post-communist states to the Council of Europe, to the EEC, to the NATO, were the origin of the maturation, or at least the ripening of multi-level constitutionalism, with the new guarantees and some problems completely unexpected. In the UK, at the end of the 90s, there was the epoch when the assimilation of many administrative figures or continental figures of administrative law was completed, and in 1998, the agreement with Ireland led to the end of the civil war in Ulster and to the symmetrical adoption of the Human Rights Act of 1998, both in Ireland and in the United Kingdom. These events led to the birth of a culture of rights different from that of the common law tradition and closer to the continental one. In the same way, Brexit should have meant the end of this experience and an opening of general reflection on the state of British constitutional law, both in the international dimension and in the domestic perspective, mainly in the light of the relationship between England and Northern Ireland and between England and Scotland. I mean, there have been several occasions where public law scholars have spoken, right or wrong, about serious crises in the state of their discipline. The pandemic has put many certainties which seemed quite consolidated to a severe test. For instance, in the area of social rights, in the field of international organization, because the behavior of the OMS apparently has been a real disaster, and it imposes a serious reflection on its future. From this point of view, I believe that President Trump is quite right from the point of view of the way of working of the OMS. Therefore, it might be time to seriously think about the future of the disciplines that compose public law. I mean, constitutional law and administrative law. However, the experience of 2008, of the 2008 financial and economic crisis, should have taught that the capitalist model can survive the most serious emergencies and even forget about the recent past. An evidence could be the partial repeal of the Dodd-Frank Act, better called the Wall Street Reform and Consumers Protection Act, after the repudiation between 2010 and 2011 of the neoliberal creed by virtually all the members of the Chicago School, like Reagan, Becker, Thaler, Murphy, Fama, and Heckman. All of them repudiated their liberal creed, but within 2 to 3 years, the system came back to the original features. So we have to suppose that the system will be able to survive even the pandemic. Obviously, a sanitary shock is something quite different, at least because it proposes unknown questions, not only to public law, but to the whole of humanity. I think I have to close. I had so many things to say still, but...
No, you have, Giuseppe, you still have, well, 5 to 6 minutes, so go ahead.
Thank you so much. I believe that in the history of constitutional law, we can distinguish 3 main stages. The first one, I don't have to enter into details with experts like the friends who attend today. First phase, the old liberal states, I mean, frame of government and Bill of Rights. Glorious Revolution, French Revolution, American independence. Second phase, democratic constitutionalism, which adds on to the liberal state long and entrenched the charters, constitutional review of legislation, which the American system introduced in the first phase, axiological charge, and extension of constitutional force to private relations, what the Germans call Drittwirkung. In the third phase, at least for Europe, because America is still living a different experience, we have courts more open or at least ajar to, I mean, the Luxembourg courts opened the door, or at least keeps it ajar, to rights since 1973, 1974, more or less. The Strasbourg court starts to decide cases concerning dozens of new states coming into the Council of Europe after the end of communism. There is, of course, the consolidation of the role of constitutional and supreme courts in balancing values and principles according to the doctrine elaborated by German scholars such as Robert Alexi, Böckenförde, and the other famous scholars working about this topic and able to export this model to the rest of Europe, I dare say, of the world, with the possible exception of the United States, where the so-called American exceptionalism has remained unique in his repudiation of multi-level constitutionalism. This model has been repudiated only by very few scholars, some rigorous positivists, such as in Italy, Pace and Luciani, some those who oppose the supremacy of the judiciary, such as in the United States, Tashnet, or such as Jeremy Walden in Canada, and other, or say Ignatieff, and in Italy maybe Carrino and Vignudelli, which represent a small minority of constitutional law scholars. A third small group of opposers of the so-called neo-constitutionalism or constitutionalism of rights is composed by old Marxists like Slavoj Žižek, who made out a living of his opposition to the culture of rights, because he goes around the world in giving speeches exposing his theory. Well, did this model of neo-constitutionalism suffer from the pandemic? Somehow it did, but I don't think that these derogations have been so dramatic to be irreversible. First of all, there has been, of course, a strong limitation of the democratic principle. The concentration of power in the executive has been already mentioned. I would mention also the continuous resort to secondary sources, which means depriving Parliament of its normative power and leaving the normative power to the government, or even to the chief of the government, to the prime minister or the premier or the chief of government, however he or she is called in the European democracies. Second, there has been a strong limitation on social rights, both on the viewpoint of under the viewpoint of health treatment and under the viewpoint of social assistance. We all have seen old persons being excluded by the National Health Service that they contributed to finance for decades. And we all have seen doctors of hospital decide between life and death for single patients, which should be completely forbidden in a real welfare state. So I do believe that we will have to think over the welfare state in terms of reinforcing or refinancing and rethinking deeply about its foundation. Third, there's been a strong limitation of civil liberties in terms of freedom of movement, freedom to assemble, indirectly freedom of speech, because of course people assemble in order to exchange opinions, and finally freedom of religion. But on the other side, we can say that the technique of balancing, the art of balancing, has been completely successful, because these problems of limitation of civil and social rights have come to the to Supreme Courts, to administrative tribunals, even to ordinary judges, and the balancing technique has been used systematically. So I believe that neo-constitutionalism comes out even stronger from the pandemic experience. There should be time to talk about negationism as well, because negationism is a way of setting the balance on quite different foundations, different from the usual balancing technique that constitutional courts have made us accustomed to. And finally, just four words, not a four-letter word, but a few words about the balancing between center and local. I mean, between federation and states, or between regional state and regional communities, or regions, or whatever they are called. Even from this point of view, probably neo-constitutionalism has turned out to be successful, because we all sometimes regret a lack of coordination between center and local power. But with the possible exception of Germany, where the coordination has worked fantastic, with Mrs. Merkel being able to keep together all the governors of the land, we have experienced something much worse in both in and in Italy, so that the Constitutional Court or the Constitutional Tribunal in Spain has not had yet any occasion to state something about this lack of coordination, but potentially, even from this point of view, I think that the so-called neo-constitutionalism has proved well enough. So I think we can say that the pandemic has been an occasion of tension, of conflicts, of strain, but possibly it has been successful, at least by now. It will be necessary to think it over within some months, maybe after summer, when possibly the virus will be completely eliminated, or at least so we hope. Thank you so much.
Thanks to Professor Ferrari. I think especially his general view of the attitude of wait and see and not to chase fashions, well, is something that is shared by several panelists. I think particularly Professor SIEMS, who will intervene as the last panelist. Now, we've had two public constitutional law scholars, Professor Albert and Professor Ferrari. Now we move to Professor POILLOT, who teaches droit privé, droit civil. I'm sorry, I'm not sure if it's droit civil or droit privé in the University of Luxembourg. And I think also private law scholars have a lot to say. I see that Professor POILLOT, Elise, has lots of slides. And so thank you for being here with us.
Yeah, no, the microphone is on. Well, io inizierò in italiano e poi passerò all'inglese e vorrei esprimere i miei più sentiti ringraziamenti ovviamente all'Associazione Italiana per la perfetta organizzazione, al Presidente anche per avermi invitata a partecipare a questa tavola rotonda con una tematica che devo dire trovo molto interessante. Vedremo se poi trovate interessante quello che sto per dire. I will switch to English because I would like also to congratulate the young researchers. I could not attend all the conferences. I'm very sorry. But the few that I attended, I have to say, I was really amazed by the quality of your presentation. So we have a very promising young comparative lawyers, and I am therefore very, I trust that the future of comparative law it will not be a problem, but let's see, because with the pandemic, we may change our mind. So I would like to start. I have to say that I was quite intrigued when my colleague reached out to me, and I realized that part of the title of this roundtable was in French, Après Le Déluge. I'm sorry, this is doomed. So now the church close to my my home is the bell is ringing. That's doomed. So that brings me back to what Richard Albert said. By the way, I have a dress, so no worries. I don't have shorts. Everybody should be fine. So yes, I was quite intrigued. Because if you look at this poem, we won't have time, but the poem is part of a collection which is called Des Illuminations. And this is an English word for, which means colored plates. That was the English part of Rimbaud's life. When he was the lover of Verlaine, and Verlaine, who knew him quite well, confirmed that the title Illuminations meant colored plates. So it's a way to illustrate, but of course you all know that both in the French language and the English language, that also evokes a combination of visual and visionary experience. So I think that this is somehow what is expected from us here. It's at the same time to illustrate how comparative law and comparative lawyers reacted to this flood, this season in hell, if I may use another title of a poem of Rimbaud. And so I will try to, at the same time, illustrate and be visionary. Be visionary, I have my doubts, but let's see. No, I'm quite sure that, by the way, Mr. President, you were not referring to the Bible, but now I had the confirmation. I was trying to look back at the Bible, and I could imagine this newsletter coming from the AIDC telling us that now this is the pandemic, and the chairs of comparative law societies, we have 2 of them, have to go on the comparative law Air Force with their whole legal families, because he, the Lord, have found your righteous in his generation, and that you should have taken with you 7 pairs of every kind of comparative lawyer, a male and its maid, her maid, and 1 pair of every kind of unclean comparative lawyer, and male and its maid. So, to be very clear, I am not going to take any question regarding who is a clean comparative lawyer and who may be an unclean comparative lawyer. This is another discussion. I leave it up to the responsibility of the organizer who invited me today. So this being said, what am I going to talk about? I'm going to talk about comparative law after a season in hell. And of course, season in hell here is the lockdown. So I will try to understand where do we stand, where are we today, and where should we go? So the illuminations after a season in hell, and try to have a vision for comparative law. Now, I will try to tackle some of the questions, some of the points that were raised to our attention by Professor ZENO-ZENCOVICH. I may be very quick on some of them because I only have 20 minutes, and I want to be, I want to respect this time frame. I would like to start with this picture. I don't know whether some of you know what Nyepi is in Indonesia. Nyepi is the day after, or more precisely, sorry, this picture is the day after Nyepi. Nyepi is a day of silence in Indonesia. That's the first day of the Hindu year. And they celebrate after that day of silence, that day of meditation, that day of fasting. So having this picture at home, I was looking at it and I was trying to think whether or not for us the lockdown could be considered as Nyepi, and I really have my doubts, but seeing all this agitation made me think about the lockdown for comparative lawyers. So maybe I will tell you about my own experience, my life, but I love talking about myself, like all academics. What I did perceive, the impression I had, is that we were doing, most of us, emergency comparative law, and at a micro comparison level. What does that mean? You have a lot of examples on the slide. I'm not going to go through them, but I really had the impression that emergency was the essence of that season in hell. Comparative lawyers were huge to perform and to deliver. And when you are forced to do that, usually functionalism is the answer. And in my opinion, functionalism was the answer. So you already understood that I'm mostly going to talk about the method. And using this expression of Tiger and Coates, I really had the impression that we were social engineers. We had to fulfill a function as comparative lawyer. We were part of the fight against the pandemic, and we had to meet the social needs. So our job was to develop legislations, legal solutions that perform this task. So I'm not going to reinvent the wheel. I mean, many scholars wrote about functionalism, many famous ones, they wrote it in a wonderful manner. I just wanted to a little bit try to understand what happened and what we should do. And honestly speaking, but again, it's a very personal standpoint, it's my perception, I really had the impression to be in the world machine, a part of the world machine against the pandemic. So I was doing pandemic, that may ring a bell, you know, it's like the World Bank and it's doing business report. And this was led by experts, by the way, rather than by government. Let's see, that's also one of the questions that was posed. So I really had the impression that we were all a little bit like this. And I realized looking at that picture that George is not at his best. I should have chosen another one. But we were emergency lawyers trying to do our best. And then the question is, using this functionalist method, was it acceptable? I would say I don't have the time to discuss it, but I will be more than happy to take your questions. Probably for some topics, yes. We really needed to perform. We needed to be realistic. We needed to answer questions. And this because we had somehow no previous experience of a total lockdown with immediate reaction required. And the role of comparative lawyer in that case was extremely important. It was also acceptable. Why? Because we all know that one of the main criticisms that is addressed to the functionalist method is that you will miss a lot of things, culture, also some factors that you should take into account when doing comparative law. Of course, for EU lawyers, it was a little bit less difficult because we're already in a uniform legal framework. That being said, I'm not saying this is the best method. I'm just trying to understand what was done and why did we do it. Is it an acceptable method? I guess for some topics, definitely not. You can see them on the screen. Because for some topics, and I would say namely constitutional law and fundamental rights, we have a previous experience of a state of emergency with terrorism. So this was not something really new. And then we're also touching upon the core values of society. And also because there is the existence of models and counter models in that field. Now, for some topics, I still have my doubts. I'm not going to go again through this. I'm more than happy to discuss it with you. Would you like me to do it? And I would try here to understand if emergency can be the essence of comparative law in such times. And I would say yes, but on the other hand, there is really a risk. And that risk is, this risk is that of doing what I would call a naive approach of having a naive approach of functionalism, thinking that, and that's what we most of the time do, lawyers, we can solve problems. We don't, we're only lawyers. We should be aware of that. So did we do our job? Yes, I think we could do it, and yes, we did. How could we do it? And that's another point that was raised in a world with limited mobility, also thanks to internet. And I think the problem to have armchair comparative, but here, dear Mr. President, this was a very provocative question. So you will get a provocative answer. I think that we already have a lot of people doing comparative armchairs. I'm not going to drop names. It's like for the unclean comparative lawyers, but you know, there are many people who do just stay at home and do comparative law. But there are also networks. And I guess this one is a very interesting example, how to gather people from different countries, how to make comparative law be alive. And with this, I really think that young researchers who are part of these networks, of course, this is not going to be any kind of full immersion, but they will have the possibility to talk to each other. Co-authoring was mentioning, if I remember correctly, Richard Albert. So there are new possibilities. It may not be true comparative law, but still, I think we also understood that there are a lot of things that we can do. Now, what vision? That's the second part of my presentation. Several questions. I slightly modified one of them. I would like to try to understand what was the role of comparative law and comparative lawyer during, I would say, the rest of the pandemic, because you mentioned that some of our American colleagues are not done with it. They are still going through this lockdown experience, which is not a nice one at all. So several questions. Who is in charge? That's a very good question. That's a very good question. I would say lawyers, definitely not. Again, lawyers, they do law. They don't take decisions. The decisions are usually taken by politicians, by parliaments, but it is true that in these extraordinary times, they were certainly taken by government more than legislature, and governments that were driven by many experts. And by the way, most of the time, not legal ones. But on the other hand, I would say that scientists also were used as social engineers, working under the same constraints that we were, emergency. Now, how do they operate? That's a very good question. I am sorry, I don't have the answer, but maybe some of you have. Now, I can try to see how they operate, at least for lawyers. And I would say, again, most of the time using the functionalist method, seen as an instrumentalist method here. And of course, and my vision will start from the risks that exist. There is a risk. The first one is picking and choosing different concepts regardless of their incompatibility with regular process or protocols. And I think there is processes, by the way. There is a very good example outside the field of law in this, which is the example of what was done by Professor Raoult in France. Everybody was talking about his experience, and we know that he was not relying on the regular protocols. So it's not only a risk that exists in the field of law, but that's a real risk also when you have this functionalist approach. And there is, of course, the risk of missing the dynamics of structural processes. Now, how does it look like? Well, we all know the problem of functionalism. And I think it is very well illustrated by this painting of Magritte. What you see is not what you think you see, or what you think you see is not what you see. And somehow I would say that during this period, we understood that reality kills legal realism to some extent. Now, second question. What should be the role, and here I'm obviously also talking to the young researchers, of comparative law and comparative lawyers during the rest of the pandemic and in the world after? Well, here again, I would like to start from the risks. I think that there is really a risk to have this simplistic perspective from outside. And we should be very careful that pragmatism does not take over on methods. They are, by the way, and I think they are, by the way, examples. I don't have time to develop, but again, I'm more than happy to have a discussion with you. There is also the risk of ignoring the latent functions that may unintentionally be caused, cultural context, technical local constraints, collective feelings. But I also saw a great advantage here, that of forcing juries to collaborate with other experts. Again, you will say that I'm talking about myself, but I was, for example, part of a workforce that was settled by the Luxembourg government. And I had to work with engineers, with doctors, with medical doctors, with people I never had worked with before. And I mean, this gate to transdisciplinarity, in my opinion, is extremely important. That's a lesson that we have to learn. Now, of course, it does not always work very well. I have a very specific example in mind because that's something I'm working on, tracing applications. This is definitely something that cannot rely only on the functionalist method. We need to understand other factors than the legal one. It's very easy to draft a legal framework, but to understand what are the externalities, why people don't trust, why people do trust Facebook. They don't have problem to provide data, but they don't trust the state. So we really need to take some time, think about it, and do not do only what lawyers think they should do, which is a law. Again, because of the risks that are at stake. So getting back to my picture and looking at it, I really think that looking at this picture, this is definitely what the lockdown was for many comparative lawyers, and among whom myself. You know, very working so many hours, also updating my lectures, trying to perform, to deliver, drafting opinions that in the end were read or not read, that no decision was taken according to this opinion. But okay, as we say in French, c'est la vie. So this was the lockdown. Now the question is, what should come after? And I would like to take some time and look a little bit at the thinker of Rodin. And I'm sure that you all know very well the thinker of Rodin, and you all know very well that he's sitting and he has his back on hell. This is supposed to be Dante Alighieri, and he has his back on hell, and he's, you know, just sitting, taking time and thinking. And I really think that the time has come to think and reflect after all this agitation. So in my opinion, what will be our challenges? Well, to take a step back, to remember also the request of accuracy of comparison, to formulate a realistic account of what we compare, so to say, to complement the functionalist approach, which I have been criticizing, but that was very useful. What about this illumination? I really hope that we will have some enlightened comparative lawyers after this season in hell. And what is the best way to end this presentation, if not to quote a book from his president, as we say in French, c'est du faillotage, but okay. I let you read, but I really think the last sentence really made me think about what we should do. We are in a complex reality, and the role of comparative law is not maybe to provide correct answers. There is never a correct answer. I mean, in the end, the correct answer is the one that is given by a judge, by a legislature, by government, whether you agree with it or not, but more engagingly to ask the appropriate questions. So young lawyers, young comparative lawyers, it is time for you to ask all the appropriate questions. Thank you very much.
Thanks a lot to Professor POILLOT for this presentation. I just would like to point out that her conclusions are not very different from those of Professor FERRARI, which shows that there's a growing consensus among comparative lawyers from with different backgrounds, with different fields of research, on the idea that it is time to think and reflect. And I think I took this down. I think that this statement, which was on one of Elise's slides, pragmatism should not take over on methods. And I think this is a very good indication. I see PG Monateri consented to this, and I think this is, I mean, it's useful also for our younger public, and I think this is a lesson for them. Now I'm very happy to give the floor to the web camera to Professor Kay, University of Connecticut, and chairman of the American Society of Comparative Law.
Thanks very much. I'm very happy to be here. I want to thank the organizers as well, Professor ZENO-ZENCOVICH and Giorgio Giannone Cotiglione of the Italian Comparative Law Association, and Antonia Baraggia of the Younger Comparatists Committee of the American Society of Comparative Law. I have had, as Professor ZENO-ZENCOVICH mentioned, I have had the pleasure of attending 3 of the prior sessions, and they were, I will echo what's been said before. They were, the papers I heard presented were remarkably interesting. And this has been a real service in a very difficult time. These are all, of course, the presenters up to today were all younger comparatists, which was the emphasis of the enterprise. Makes me feel somewhat out of place, because as you can probably tell, I myself am not a younger comparator. And I was thinking about it actually earlier, and come to think of it, I have actually never been a younger comparator. By the time I got to study comparative law, I was already too old to be a younger comparativist. So I want to spend a few minutes speculating on the future of the discipline of comparative law in light of the pandemic, which we have all been suffering through. My colleagues who have preceded me have mentioned many of the things which I agree with, and I will be to some extent repeating what they have said. So what's going to change? We know that many, many things in the world are going to change as a result of our experience. And they're never going to go back to the way they were. For example, I think that Richard Albert mentioned this, we're never going back to the way we used to communicate with each other. That is, we are going to be Zooming even after we have become brave enough to get back on an airplane. And speaking more particularly to the academic world, in addition to conferences like this, online conferences, I'm sure you have all had the experience of being pushed unwillingly, excuse me, but more quickly into the digital world of instruction than we might have otherwise.
Richard, why did you have a glass of water?
I will.
We can wait. No problem. We can wait. I mean, this is this.
I will. I think I'm back on track. Thank you, though. So we've been pushed into digital lecturing much sooner than I think you would have heard. And what about comparative law? Will this COVID experience promote or retard the study of comparative law? Well, it may not be the same everywhere, of course. But I want to talk about how comparative law changes, or how the attention to it has changed, at least in the United States, which is, of course, the jurisdiction that I know best. And I suspect there'll be many other countries where the experience has roughly been the same. Before the onset of this epidemic, I have observed in the course of my career an extraordinary growth in the academic interest and in the practical interest in comparative law. Since that time, when I, already middle-aged, came into the field. When I began studying comparative law, I think I can say accurately that it was a truly insignificant part of the American Legal Academy. At that time, a majority of the US law schools probably had no comparativists on their faculty. And to speak to public law, which Professor Ferrari spoke about, that was an even rarer species than comparative private law. These days, on the other hand, comparative law occupies a much more important part of the US Legal Academy. I agree with Richard Albert that a comparativist on a law faculty is still considered something of a luxury, but it is in fact now, that luxury is in fact being consumed by many, many law schools. It's the rare school these days that does not at least offer comparative law courses. Institutionally, the American Society of Comparative Law, when I first began attending its meetings in the late 1980s, had maybe 40 to 50 institutional members. Now we have, the last time I looked, 110 institutions as members of the society. And I think probably a majority of American law schools now are members of the American Society of Comparative Law. The volume of publications on comparative law has exploded in that period. And not just in specialized journals like the American Journal of Comparative Law. in the more general American law reviews, one cannot avoid seeing comparative treatments of various books by American authors on comparative law have substantially increased. I think Richard Albert, who is the book review editor of the American Journal of Comparative Law, can either dispute or confirm that statement. So what's happened in the last 30 years to account for this change? Obviously, there are many factors. I just want to dwell on one of them, but I think it may be the most significant, and that's technology. Which, by the way, it was a subject which was very usefully explored in papers which this series had last week in the 2 sessions that were given last week. So what's happened? What technological changes am I talking about? First of all, transportation. From the time that I started until now, transportation has become vastly more affordable, which in normal times would allow the kind of personal collaboration between scholars in different jurisdictions, which is, as has already been pointed out by some of the previous speakers, essential for informed comparative work. And also, I've already mentioned electronic communications, allowing the kind of international meeting that we are in right now. The digitization of archives is something Professor Ferrari mentioned, and at least for people in my generation has been absolutely astonishing in the change that changes the nature of our work. And critically for comparativists, especially helpful in that it allows us to examine data and text from all over the world with almost no trouble. I started out in the academy in the early 1970s, and I can only tell you, certainly I can only tell the younger people, that the methods of scholarship were utterly different. Legal databases, email, web search, word processing, none of that existed. And I would ask, especially the younger people, to think about their own work and how it would proceed if all of that stuff were taken away. I remember that in 1992, I undertook to write an article with a colleague who was at the University of Missouri. I was in Connecticut. Well, we collaborated by email and exchange of drafts, and when it was submitted for publication, I recall I had this kind of sense of wonder. I'd kind of go and talk to people to tell them what had happened, that we had been able to do this from start to finish without exchanging a single piece of paper. That's something which was science fiction in the 1970s. But you get the point. Technological changes have made possible what we call the globalization of information, a development which opened up new horizons for scholarly research. And globalization obviously was had an especially powerful impact on international and comparative law. Nowadays, I think, when legal scholars take up almost any subject, they may start from a strictly domestic viewpoint, but increasingly, it will be less and less possible to get into that subject without bumping into information about how other jurisdictions deal with the issue. Of course, I'm preaching to the choir in this session, but I expect you will agree with me that once the possibility of comparison becomes clear, thereafter it becomes almost impossible to deal with the subject in any other way. So what does the emergence of COVID-19 have to do with it? I asked initially, will this experience end up stimulating more comparative law research, or on the contrary, might it encourage our legal scholars to remain in the limited world of their own national law? We shouldn't utterly dismiss the second alternative. There is a sense, I think, in which any period of acute social stress is a bad time for comparative law, because those are the times when a society tends to turn in on itself, when it becomes suspicious of outsiders. And in this case, the virus itself, metaphorically, is seen as a kind of a foreign invader. So we have seen many countries sealing their borders to keep the trouble out. In the United States, we've seen the same strategy employed, and still is being employed, to diminish, to reduce intercourse among the various states. That is, as mentioned earlier, federalism has been getting a boost because of the pandemic. And as foolish as it sounds, wouldn't be all that surprising that people might want to seal their intellectual borders as well as their physical. Now, of course, in most aspects, this strategy is entirely irrational. And as you might expect, my take on what's going to happen is the opposite. Let's think for a minute about the legal subjects that the pandemic is now bringing to the forefront of legal research. Laws about organizing public health service, about quarantines, about the regulation of businesses which may pose a health hazard. It seems to me that these subjects actually present a particularly fruitful target for comparative research. And more specifically, for the functional legal comparison to which Professor POILLOT was referring. That, of course, is the kind of research which probably has been around forever. When we examine different legal machinery in different jurisdictions for dealing with the same problem, in the hope that we will be able to identify better, faster, easier ways to solve that particular problem. But as also you heard from Professor POILLOT, functional comparative analysis has generally been especially in recent decades, has been the subject of significant academic criticism by people who have claimed that very often what's happening in one jurisdiction is not all that relevant to what is supposed to be the same thing in another, because the comparison neglects the distinct histories, traditions, cultures of the societies in which legal rules are necessarily embedded. Now, there are some aspects of public health measures that require exactly that kind of caution in the process of making comparisons. But I think that when we are talking about the law's response to a disease, that worry will in many aspects be less plausible than it is in other subjects of regulation. Because the basic problem that we are attacking is more or less identical across jurisdictions. insofar as it's a matter of human physiology. You have been following the response to the pandemic in the United States. You will notice that the way to deal with it has itself been the subject of acute political division, like everything else in the United States. When this political acrimony arises, it's very common for somebody, usually some doctor, to say, you know, the virus doesn't know whether you're a Republican or a Democrat, which of course is true. And I think the same thing might be said about whether someone is an Italian or a Russian, whether you're a citizen of a civil law or a common law jurisdiction. The virus is the same. So, for example, if we are interested in the value of a law that requires certain testing protocol, or that mandates face covering in certain situations, or that closes businesses with some inclusions and some exclusions, in those cases, I think it seems obvious to make sense to compare the experiences in different places, those that did and those that did not impose various measures, and see what happened. Again, I don't mean these questions may be dealt with by just pulling texts up on your computer screen and comparing them. That's foolish and never the case. But many of the things which we have been and will continue to be dealing with in the pandemic are the kind of legal phenomena that more or less scream out for comparative evaluation. So to get back to the main question, I'm pretty sure comparative law is going to be, the pandemic is going to be contribute to those forces that I've already described, which are pushing comparative law to the front in legal research. And as we continue to cope with this situation, we're going to find it more and more normal, harder and harder to do. So I think to conclude that as a result, comparativists, there are going to be more comparativists coming out of the pandemic than went into it. And I think for us anyway, this is further evidence that nothing is so terrible, but that it does not have a silver lining. Thank you.
Thanks a lot to Professor Kay for this, also this optimistic finale. Just for our younger scholars, I mean, as you mentioned, the sort of relationship with comparative lawyers having to tackle with numbers, I just would like to remember that in Professor SIEMS' handbook, there's a whole chapter devoted to comparative law and numbers. And so now it's the time, as you see, I mean, the majority of the panel, Professor Ferrari, Professor POILLOT, and yourself, have a very cautious approach and say, wait and see from different perspectives. Yours is a pragmatic approach and looking at, let's look at facts. And I think this is something we should instill on our younger public, just to say, well, yes, they can be involved in some instant article on the topic, but they should also somehow put a caveat at the beginning saying, well, things are developing and we don't have to chase the events. Now, we don't have much time, really, we have very little time, but I would like to somehow sort of invite, as we have some eminent scholars, we have Professor Monatelli, Professor Somma, Professor Miranda, Professor Calzolai. I'm just mentioning those who are online here. I just wanted to ask them if they want to intervene on the debate, thinking that this is also an occasion to join together Professor Sika. I see him now online too. If you want to intervene very rapidly and sort of with discussing with the panelists and obviously giving some pills of wisdom to our younger public. Is there someone who wants to take the microphone? Professor Monateri, Professor Somma, Professor Sika, Professor Miranda, Professor Calzolaio? No. No other?
May I say something? May I say something if I have the possibility?
Yes, sure.
Okay, sorry, because I did not have the time to mention this, but I think it is going to be a very important topic in the forthcoming month, that of liability of governments. Here will, of course, I'm not sure it's going to be really new comparative law, but I think that lawyers will be busy trying to see how the different legal systems reacted to people seeking liability of governments, of states, of experts, because, you know, after Après Le Déluge, usually people try to find who could be held responsible for this, liable for this. So I think this is also going to be certainly a topic, a hot topic and a topic for discussion. I did not
Thank you, and I think this, you've offered the floor to Professor Monateri, who is an expert on liability, and so and has raised his hand.
Well, I raised the hand just because nobody was doing it, but I shall try to cope with some of the many questions who have been raised.
Rapidly, PG.
Yeah, very rapidly.
Yeah,
Anyway, I think there are two major sides of what we have heard. One is a bit the opportunism of comparative law. Now, a state of emergency is in fashion. Now we have to cope with a state of emergency. Now, state of emergency has been around for many years, indeed. And I presume that 3 years ago, none of the present would give any consideration of state of exception or the constitution of emergency of Bruce Ackerman and other topics like that. Where now, typically of comparativists, is the opportunism of seeing in the state of emergency a new topic for comparative law and its development. This is just one side of the story. The other is very intriguing and has been raised by the Americans especially. It is rethinking the canon and history of comparative law from the perspective of young scholars especially. Well, I think this is very important because this globalization of the state of emergency is maybe a fourth kind of globalization. If there we have experienced certainly a first kind of globalization, classical legal thought. I mean, private law, freedom, liberties, and so formalism, positivism. Then we experienced the globalization of the social welfare, labor law, advanced rights, and so forth. Now we are experiencing from 2000, 2001 maybe, beyond, a kind of globalization of emergencies. United States, France, many other crises, Ukraine, and now a global lockdown. And maybe this is an impact, really may have an impact on legal thought. Very different from the social and from classical legal thought. What we are experiencing is something going beyond policy analysis on the way we try to systematize adjudication and policy analysis in the law in the last 30 years. And I think it will be important for legal theory, maybe to focus on this aspect, rethinking the canon, because when we change the paradigm, we must reshape the canon of authorities and precedents. So that's just my point, but just in order to be very, very, very brief on all the important matters you raised. Okay,
thank you, Professor Monateri. Is there someone else who wants to take the microphone? Professor Sika, Professor Somma? None? Nobody else? No? Okay. Then if there are no other sort of interventions, and it's exactly 1 minute past 8, I just want to, Professor Ferrari has mentioned this, but it's connected to what PG Monateri has just said, sort of the notion of emergency. This we've had from 2001, we have terrorist emergency, security emergencies, and then we've had environmental, natural disasters. Just think of the tsunami, which hit many countries in the Far East. And then obviously we have migration emergencies, and now the pandemic. So I think that probably we haven't yet decided. The steering committee of the Italian Association of Comparative Law has not decided yet, but we think that next year's biennial colloquium could be devoted to comparative law and emergencies, both from a theoretical issue, and PG Monateri has put this out very clearly, and also looking at the sort of specific aspects of this. Obviously, the colloquium, as usual, will be based on call for papers, and so there will be an occasion to propose different views of the issue of emergencies and comparative law. Having said this, I wish to thank again our Antonia Baraggia and Giorgio Giannone Coriglione, all the participants to the webinars. I see Giannone there, he is. Finally, we see him, the man behind the anonymous, Mr. Anonymous. Yeah, he is. So now you finally see Dr. Giannone. I mean, he's, and also I would like to thank the over 40 young comparativists that intervened in the various webinars, and it was great having them from various parts of the world, Northern Europe, Italy, across the Atlantic, Canada. It was great, and I think it was this, as this was made very clear by Richard Albert in his first intervention. This was a real great occasion to have a community. Having said this, thanks. I see Richard there. Thanks to everybody, and we hope we meet again. Well, as you know, Italy is very hospitable, and so we do hope to have you here in Italy and to give you Italian food and wine, but also, if not, we can't pour wine through the webinar, but we can somehow get together online. Good evening to everybody. Good morning to our American transatlantic friends, and see you soon.
Thank you.
Ok. Ciao, ciao Zeno, grazie.
Ciao, grazie a tutti.